Dear learners, we have been discussing about the theories of human rights, and we already discussed the natural rights theory, its critical appraisal, and then its contribution to the discourse on human rights. After that, we are going to discuss today the legal rights theory. After natural rights theory, the legal rights theory is one of the important theories that tries to explain the claims for human rights. In the legal rights theory, first of all, we will try to introduce the topic, and after that, we will deal with the explanation part. Our previous class discussed the natural rights theory, which believes that rights are natural. So we found that how John Locke tried to justify the rights as natural. We also found that they say that human beings are born with certain inalienable rights. So, in the natural rights theory, we discussed that man is born with certain inherent and inalienable rights that cannot be taken away. We critically evaluated the theory and found that the term nature itself is ambiguous, and the rights this theory promotes are difficult to identify, justify, and realize. For example, if we say that certain rights are natural, then who will implement those rights? If the law of nature is there, then who will interpret the law of nature? If there are more than one interpretations, which interpretation should be accepted and which interpretation should be rejected? These are the puzzling questions that natural rights theory is not able to answer. While discussing about John Locke, we found that this was the problem in the state of nature as well. The state of nature was good, there was mutual goodwill, it was a peaceful state of nature where people were enjoying their right to life, liberty, and property. But the problem was that in that state of nature, that an element of uncertainty was there. Why? Because of the law of nature had many interpretations. So finally, John Locke finds that in the state of nature, three things were missing. Number one was legislature, means this law of nature was not codified, so that was the problem. So that is why, what is law of nature? More than one interpretations were there, and because of that, there used to be conflict sometimes. Of course, because of the rational nature of man, they were able to resolve that conflict, but conflicts were there, they were arising. After that, we find that if the law of nature is there or the natural law is there, then who will implement that natural law? Because there was nothing like what we call executive today. After that, John Locke says, that if the dispute or conflict of opinion is there so far as the interpretation of law of nature is concerned or the natural law is concerned, then there was no final arbiter that we call judiciary. So that is why, legislature, executive, and judiciary, they were missing. This was the weakness of the natural rights theory. The rights claimed by the exponent of this theory were dependent upon the recognition by the state and its laws. This was the main weakness of the theory. So that is why, you see, for example, if law of nature or if the natural law or if the nature has given some rights, then these rights need to be recognized by the society and the state. If the state does not recognize rights, then they will not become the legitimate claim. So that is why rights need to be supported by the power of law. The inherent weakness of the natural rights theory made the claims of rights shallow and hollow. Under this kind of circumstances, what happens that, you may claim certain rights as, they may be lofty slogans, they may be inspiring slogans, they may bring revolutions, but ultimately the state, which has sovereignty, which is internally supreme and externally free, that must recognize these rights. And because of that, when the claims to rights were proving to be hollow and shallow, under this situation, what happened that therefore a new theory was needed to justify the individual's claims to rights. The legal theory of rights was developed to legitimize the people's claim to natural rights. So you see, this gap was there. This gap was filled up with the legal rights theory. The legal right theory claims that rights are not rights unless recognized by the state and protected by the laws of the state. You see, this is a very, very important development, because what happens when the state has been established? If we believe in the social contract theory, then if the state has been established, then what is the purpose of the state? It is to provide security to people and to promote their happiness. According to John Locke, the father of natural rights theory, the main job of the state was to preserve liberty, right to life, liberty, and property. How a state will, protect these rights? Because if these rights are natural, then these natural rights must be incorporated in the law made by the state. So, unless the legal sovereign recognizes the natural rights will be only shallow claims. So, this is the reason that this theory claims that rights are not rights unless recognized by the state and protected by the laws of the state. However, it does not claim that the state creates rights. This is again important to understand, that rights are there. The legal rights theory is not saying that rights are created by a state. It is not saying that the rights are created by law. It does not say that a state is the source of rights. What it claims, that the rights, they may be natural, they may be moral claims of the people, but these moral claims, or these, the rights regarded as natural, they must be accepted to the society, they must be acceptable to the law, and they must be protected by the state and its laws. That is their claim. So they are not saying that, the rights are the gift of a state. This legal rights theory simply maintains that the realization of claims to rights depends upon the recognition by the state. So if the state does not recognize a particular set of rights, then the rights will be just, you can say, moral claims of the people. It will not be having any kind of sanction behind it. Thomas Hobbes is among the earliest exponents of the legal rights theory. Thomas Hobbes, you all know, was a social contractualist, and he is among the earliest exponents of the legal rights theory. Like John Locke was the exponent of the natural rights theory, Thomas Hobbes was the exponent of the legal rights theory. Thomas Hobbes maintains that without authority, rights cannot be realized. He established a logical relation between rights and authority. Here we should go back to the state of nature of Thomas Hobbes as depicted in his celebrated book, The Leviathan. Through his theory of social contract, he exposed the fallacy of rights without authority. And that is why it is important to revisit his social contract theory to better understand this legal rights theory. Like all social contractualists, Thomas Hobbes also believed that there was a stage when human beings were living without a state or without external regulation. Like John Locke, Thomas Hobbes also believes that all the people have equal natural rights in the state of nature. Equal natural rights, keep in mind. There was no common superior it means everybody was equal. And that equality and the claim of equal natural right itself was the problem in the state of nature according to him. As we have been explaining, that a state of nature means, according to social contractualist theory, a stage in human history when the state had not come into existence. So that is why the necessity of the state is to be understood, first of all. So ultimately, in the state of nature, what was happening? That since everybody was claiming a right to everything, and there was no common superior to determine who is wrong and who is right, whose claim is legitimate and whose claim is not legitimate, under this kind of circumstances, we will find a lot of problem out there in the state of nature. And it ultimately led to what is called the war of all against all. There was open cutthroat competition. In the state of nature, there was war of all against all. There was no place for industry. There was no peace. It was a perpetual war-like situation was there in the state of nature according to Thomas Hobbes. Then Thomas Hobbes says that what happens when the people realized, you see, the reason that was lying dormant at that time because of this kind of situation, that sorry state of affair that prevailed in the state of nature, people got fed up and the reason came to rescue. The reason that was lying dormant got activated, and finally people tried to find out the problems in the state of nature, and finally they found that it was because of the equal natural rights without common superior, equal natural rights without external regulation of the behavior of man, that was becoming the problem, which was leading to a state of war in the state of nature. And according to Thomas Hobbes, in the state of nature, what was the situation? That the life of man was solitary, nasty, brutish, poor and short. So that is why the people now, under this kind of situation, they were craving for peace, and that is why they entered into a contract. What is the terms and conditions of the contract? It is not a contract between the ruler and the ruled, rather it is a contract between the people. And what, people enter into a contract by saying that I authorize my right of governing myself to this man or to this assembly of men, on the condition that you give up your rights to him and authorize all his actions in like manner. The self-governing right that the people were enjoying in the state of nature, which was responsible for the perpetual war, here what is happening, that the people are going to surrender that right and authorizing the legal sovereign, the sovereign who is also the beneficiary of the contract, to regulate their behavior, authorizing all his actions. So ultimately, the legal sovereignty is created. So we find that if the rights are there, but if they are not being regulated, if there is no common superior, if there is no authority, if there is no codification of those rights, then what will happen? That there will be perpetual war-like situation. It will just be like anarchy. So this is the reason that we have to understand the significance of law, the importance of the state so far as the implementation of the rights as legitimate claims of the people is concerned. In the absence, as we pointed out, in the absence of authority, the equal natural rights claimed by individuals made the state of nature a state of perpetual war and conflict, according to Thomas Hobbes. So we should see that the Hobbesian state of nature was a state of war, whereas the Lockean state of nature was a state of peace. That is the fundamental difference between the two. Among the proponents of legal rights theory, we find one of the most prominent name is of Jeremy Bentham, who was the father of the utilitarian school of thought. Jeremy Bentham not only criticized natural rights theory as nonsense upon a stilt, but he also highlights the importance of law in the implementation and enjoyment of rights. Bentham says, and I quote, "Rights are the fruits of law and of the law alone. There are no rights without law, no rights contrary to law, no rights anterior to the law." What kind of relation he is trying to establish between law and rights. I am repeating, rights are the fruits of law and of the law alone. He is saying there are no rights without law, no rights contrary to law, no rights anterior to the law, unquote. So it means it is law that is making our rights effective. Without law, without the recognition of the law, rights will not be effective. You can imagine a situation in which there is an anarchy. In the anarchic situation, we cannot realize our rights. Even the basic right to life will be in danger. Right to property, of course, will be in danger. Dacoits, murderers, criminals, they will be doing whatever they want to do. Might is right will become the governing principle in the anarchic stage. So that is why law is such an important thing according to Jeremy Bentham. We also find that, like Bentham, Ernest Barker also supports the legal rights theory. And he maintains that law contains rights and indeed is rights. Law and rights are simply the two aspects of something which is essentially one, according to him. Ernest Barker is saying that law and rights are simply the two aspects of something which is essentially one. It means there is no difference between law and rights. It means law is there to promote rights. If there is no law, rights cannot be promoted. Rather, rights and laws are one, according to him. Legal rights are the claims and interests recognized by the laws. You see, there may be many claims in the society. People may claim anything. But ultimately, what will happen? Finally, there is to be a consensus in the society, and that is to be accepted by the state. So what happened? Legal rights are the claims and interests recognized by the laws. Different countries, according to their own cultural traditions, etc., you will find they devise different kind of law and different kind of rights are recognized. For example, in many countries of the world, we find that the lesbian and gay rights have been recognized and the legitimacy has been provided to gay and lesbian marriages. But there are other countries who criminalize, these kind of inclinations. So we find different kind of countries. There are countries who have gone for the criminalization of the live-in relation, criminalization of the gay and lesbian inclinations. There are countries who have already decriminalized it, and there is a third category of the countries who have already not only decriminalized it, but they have already legitimized it. So ultimately, something which is recognized by the law of a country becomes the legitimate claim of the individual. That interest will be considered as legitimate interest which is recognized by the state and its law. So that is why it is said that legal rights are the claims and interest recognized by the laws. We can take another example. During the apartheid era of South Africa, the rights, according to the constitution at that time, that apartheid constitution, it had recognized the privileges of the white people. But after that, you will find after the revolution under Nelson Mandela in South Africa, the same privileges that were there for the white people and all the baggage that was imposed upon the black people, now that is no more there. So that is again one of the best examples to understand the rights and laws are interlinked. While explaining the rights and the connection between rights and laws, we have to also understand that it has two dimensions. Number one is domestic, and the other is international. So, rights recognized by the domestic law of a country, they may be there. For example, the Constitution of India. Under the Constitution of India, we have recognized certain rights as fundamental rights. There are certain rights that we have recognized under the DPSP, we the people of India, in the Constitution of India. Similarly, like our own constitution or like the constitution of our neighboring countries or the Constitution of America, you will find all the amendments that were there in the American Constitution to accommodate the claims of the people as rights, that we can find. So ultimately, they are domestic laws. The domestic law means constitution or other kind of laws, those who are recognizing the rights within the boundary of a country. But we have also discussed that human rights transcend national boundaries. So that is why there is an international law also, that at the international level, certain rights have been recognized under international law. For example, Geneva Conventions. For example, the international humanitarian law. For example, the treaty-based laws under the aegis of the United Nations that have been developed. So ultimately, the laws may be international law or law may be national law. A country has, for example, if a country is a party to an international treaty, then it becomes the international obligation of that country to implement the provisions of that particular international law within its territory. For example, India has signed, or India is a party to the Convention on Genocide, Convention Against Genocide. So ultimately, India's international obligation is to see that genocide is not committed in the country. There must be also a corresponding law. Similarly, we have signed CEDAW. So all the provisions of CEDAW, they are to be implemented in the country, and we have our international obligation towards the United Nations, and India can be questioned on the rights of women in the country or the status of women in the country. So we find these examples like amendments in the US Constitution recognizing certain claims as rights. Similarly, principles of the treatment of prisoners of war under the Geneva Conventions are the examples of international legal rights. The example of domestic law, we have already given the constitutions of the various countries. The scope and content of legal rights can vary significantly across different countries and legal traditions. That is also, we have to understand that the legal rights vary from country to country. There are certain rights, they may be declared as legal, legitimate in some countries, and they may be illegitimate, illegal to enjoy those kind of claims as rights in other countries. For example, countries implementing family planning and countries not implementing family planning. For example, one child policy was there in China. So it means according to Chinese law, more than one child was not allowed earlier. So it means that was their law. On the other hand, we find there are many countries who are giving incentives for producing more and more children. So that is why, it all depends upon the challenges, circumstances, needs of the countries. We also see that the culture is also a very, very important factor so far as the recognition of the scope and content of legal rights are concerned. For example, there are countries, they have legalized polygamy, but there are many countries who do not accept polygamy. Similarly, we find that who is a child, the determination of the age of child. For example, what should be the age or marriageable age of a girl and marriageable age of a boy? You'll find it also varies from country to country. So under this kind of circumstances, what can we understand that the scope and the content of legal rights can vary significantly across different countries and legal traditions. Legal rights theory emphasizes the importance of positive law in securing and enforcing human rights. We have one thing that is called natural law. Natural law is not made by a parliament of human beings or the legislature of human beings. They are there. Now, what is natural law? Is it the natural inclination of the people or the very nature of human being that you can say is governed by the natural law? Then why the different kind of inclinations are there? What inclination is to be considered as natural? Can we say that the biological relation between male and female is natural and the lesbian inclination is not natural? This kind of debate you will find today. So that is why legal rights theory emphasizes the importance of positive law in securing and enforcing human rights. Positive law, it means that the law which is codified or made by human beings and they have legal sanction behind them. So that is why we cannot ignore this factor that there may be many claims which can be called as natural claims or the justifiable claims or moral claims, but unless they are recognized, codified by the positive law, these claims will not become rights. The natural rights theory also argues that relying on abstract and contested notions of natural rights is insufficient and that clear legal recognition and enforcement mechanism are essential. Rights are not only the golden words written in the constitutions or the law of the land. They need to be implemented. And for implementation, you must have some kind of enforcement mechanism. For example, we say that Universal Declaration of Human Rights adopted by the UN General Assembly on 10 December 1948 is only a declaration. It does not have implementation mechanism. And we say that the ICCPR, that is International Covenant on Civil and Political Rights, that is a legally binding treaty. So that is why the implementation mechanism is also there. In our own country, for example, we have many fundamental rights in Part 3rd of the Indian Constitution. But these rights are not enough that they have been mentioned in the Constitution of India. We have, in the Constitution itself, we have writs under Article 32 of the Indian Constitution to implement our rights. The 5 writs that are there in the Article 32 of the Indian Constitution. Similarly, judiciary in our country, of course, the Supreme Court, High Court, they are, we can say it is the guardian of the Constitution of India, at the same time custodian of the rights and liberties of the people. So for violation of fundamental rights, we can approach the Supreme Court of India even. And, it will issue writs. So what we have to understand that the enforcement mechanism is there. Not only this, we have also many extra constitutional bodies. For example, there are safeguards for minorities in the Constitution of India. And to monitor the safeguards and their implementation, we have National Commission for Minorities. There are many rights that are there for the women. The principle of non-discrimination is already part and parcel of the rights that are there in the fundamental rights. So, but there is already a National Commission for Women. This is also an institutional mechanism to implement the rights of women. Similarly, we have National Commission for Scheduled Castes, National Commission for Scheduled Tribes. These commissions, institutional mechanism, they are providing efficacy to rights. So the rights will become effective only when they are being implemented. Uh, it argues that relying on abstract and contested notions of natural rights is insufficient and that clear legal recognition and enforcement mechanism are essential. After that, what we have to understand, the critics argue that legal rights theory can be limited by the power of the state and its willingness to uphold human rights principles. This point is again important, that when we are trying to understand the legal rights theory, we have to remember that states are most of the time not very happy to recognize the rights of the people. So that is why what happens, that they may, the under this, the legal rights theory can be limited by the power of the state, which is internally supreme and externally free, and its willingness to uphold human rights principles. So you'll find most of the states of the world, they make the law, for example, preventive detention laws, and in the name of preventive detention laws, you will find blanket power is given to the police and the security agencies, and these security agencies or the police is violating the rights of the people. In many countries of the world that happens. So that is what happens, that the states, they can take away the rights of the people, even the right to life and right to liberty of the people, that can be curtailed. And that has become a tendency these days, that the state is becoming powerful, so powerful that they are trying to maintain what is called industrial peace in the name of security, national security, internal security, external security. They can chain the citizens in their own country. The contribution of legal rights theory now we are going to understand. It provides a clear and concrete framework for protecting human rights through legal mechanism. Of course, there is no doubt. It holds a state accountable for upholding human rights obligations enshrined in national and international law. So we have already discussed about the international obligation of a country, as well as the national law and the national mechanism to implement human rights. Then legal rights theory has been instrumental in advancing human rights through the development of international human rights law, national constitutions, and domestic legal frameworks. This is of course a major contribution of legal rights theory, that people mounted pressure on the state or the authority or the government to recognize their claims as rights and incorporate them in the constitution or in the national law. It also provides a clear basis for holding states accountable for their human rights obligations and empowers individuals to seek legal redress for violations. This is important. For example, if there is no international law of human rights, we, on the basis of the UDHR, that is Universal Declaration of Human Rights, International Covenant on Civil Rights, International, Treaty Against Torture, International Convention Against Torture, or International Convention Against Genocide, on the basis of this, we can identify certain countries as violating these laws. So the rights that have been codified, they have been incorporated in the international or national law, that is also holding states responsible for implementation or violation of those rights which have been already mentioned in the constitution or the law. So that is why this is very important. Legal system can be manipulated to restrict or violate human rights. Again, important. Legal systems can be manipulated to restrict or violate human rights. When we rely upon the legal rights theory and the law alone, what happens, that the legal systems can be manipulated. There are, in the law you will find that there are clauses, they are called reasonable restrictions. So the reasonable restrictions, sometimes they become the restrictions that are not reasonable, and they restrict the freedom of individuals, freedom of the citizens. So that is why the legal systems can be manipulated, and it is manipulated by the state. So that is why fake encounter can be justified by the state. Brutal torture of its own citizens can be justified by the state. Third degree torture, which is a common feature in most of the countries of the world, that can be justified by the state. Again, access to legal remedies may be unequal and limited for marginalized groups. In a country like India, we have to understand about it that the cost of justice is very high. So, for example, if a person's rights have been violated or infringed upon, that person is, if he is trying to seek the help of judiciary, he has to start from the lower court and he has to go to the high court and the Supreme Court, and that will take a lot of time. So, for marginalized communities, individuals, it becomes very difficult to realize the rights that the legal rights theorists are trying to promote. While legal rights theory offers a powerful framework for protecting human rights, it's crucial to acknowledge its limitations. State power, potential manipulation of legal systems, and unequal access to justice can hinder the effectiveness of legal protections. So, the state power, an individual is placed against the state. For example, if a state is leveling a charge of terrorism or treason on an individual, that it is the onus is of that individual to prove that he is not a terrorist or he has not committed the act of treason. So, on the one hand, you have the paraphernalia of the state. On the other hand, the poor individual is trying to prove his innocence. So, that is why it becomes very difficult under this kind of circumstances. Recognizing these weaknesses emphasizes the need for complementary strategies beyond legal frameworks, such as international pressure, civil society monitoring, and empowering marginalized groups to claim their rights. That is why we cannot rely upon states alone. So that is why there are non-governmental organizations, social activists, human rights activists. They are trying to monitor, and when they are trying to monitor, they are bringing out reports on the violation of the rights against the state. And this kind of pressure works, and that is why most of the time we will find that the state are under tremendous pressure of these organizations, because they are independent organizations, they are non-governmental organizations. Many of these organizations are not taking funds from the corporate sector or from the state because they want to maintain their independence. So that is why these organizations are playing an important role. Now, in conclusion, we will say that the legal theory of rights has played an important role in recognizing the legitimate claims of individual as rights. The main weakness of the natural rights theory was that it suffered from ambiguity. This was the legal rights theory removes this ambiguity and gives rights a concrete shape through legal sanctions. It is also important to note that recognizing a specific claims of individuals as rights is not a favor the state bestows. Contrarily, the recognition of rights by the state provides legitimacy to the power and authority of the state. So it is not a favor that is bestowed by the state. Rather, it is going to provide legitimacy to a state if a state is recognizing and enforcing the rights of the people. We should also note that a state is both the protector and violator of rights. And the best example is that, a study was conducted by Bisauni that how many victims of terrorism were there in 20th century from 1901 to 2000. And he found that in 100 years, in the 20th century, 1 lakh people were killed in non-state terrorism, and 70 million, that is 7 crore people, were killed in state terrorism. So that is why we have to understand that state is the protector as well as the violator of the rights. So that way the constant check on the authority of the state is very, very important. Thank you very much. We have already concluded our lecture on the legal theory of rights. Now in the next class we are going to discuss the historical theory of rights. Thank you.